Hello all, welcome to Coffee with Marci. I'm here at Tarta Law with attorney Steve Tarta, and we are here in Midland Park. Welcome.
Thank you so much.
Thank you for welcoming to your offices and giving me this time to explain to everyone about you and what you do.
Our pleasure, thank you for being here.
Absolutely. So tell us first, how long have you been in practice?
I've been in practice since 1972.
Wow.
And I started out as a county prosecutor, and therefore I was in an entirely different world, prosecuting criminal activity. That lasted for approximately 5.5 years, and then from there I went into private practice with a very general practice in the beginning, which drifted into automotive law, believe it or not.
Wow.
I ended up going from representing 1 through 6 automotive franchises within 2 years. It grows very, very fast.
Yeah.
And then I became interested in the estate planning area because I had a client that was referred to me, and we became very good friends over the years. One thing led to another, and she had a very large estate, which I ended up representing upon her death, and it just became an addiction.
Oh,
Truly
wow.
an addiction.
So, you found your passion in,
Yes.
in law.
Yes.
Yes. So what is your approach to estate planning?
My approach to estate planning is for me to dwell and to find out from you your best approach for asset preservation. What can we do so we can preserve your assets for your chosen beneficiaries?
Right, so people come in here and they are not sure of what they want to do. So that is what you're talking about, asset preservation.
Correct.
So you're telling them exactly what their assets are and how tell us exactly what that means, preserve them.
What that really means is when someone comes in for a consultation, the 3 things that we're going to dwell on in the initial consultation will be a will, a power of attorney, and a healthcare proxy.
Okay.
All right, and then going back over those wills, very basically, most people come in here with an understanding that they need a will because that need has never been addressed. And most of the time, the client will tell me, I need a will so that in the event of my death, everything will pass to my spouse. In the event of our death, will pass to our children. That is commonly referred to as a I love you will. And it works, it's fine. It accomplishes the objective that you have when you walk in the office. However, I want to go beyond that and say, have you ever discussed or contemplated the expense that you will incur or your estate will incur in the administration of your estate? So from there, we have to determine what that number is, and I usually refer to my website for that purpose, because I have a calculator on my website that will determine exactly what your expense will be for probate expense. This is not taxation. This is probate expense.
Okay.
That represents all expenses that will be incurred from the moment of your death through the administration of your assets to your beneficiaries.
Well, I don't think that's anything we think about that.
Most people don't.
No.
Most people don't. It's an unpleasant thought,
Right.
bluntly. So therefore, by denial, or we'll get to it tomorrow, or postponement, we don't necessarily agree to address that as we should.
And when do you think people should come in to start thinking about this?
Very interesting question, because the earlier the better, obviously.
Right.
However, most people normally start contemplating seriously the estate planning arena usually by the age of 60.
Right.
I would prefer to see them become more familiar with it somewhere in their 40s, but that doesn't happen often enough, I don't think. The reason why I like someone earlier than their 60s is because if we can start thinking in terms of when I die as opposed to if I die,
Right.
then we can start putting things into proper perspective. And all of a sudden we do realize these are issues that have to be addressed.
And I think we're seeing today that it is very important, to address these things sooner, because unfortunately people in our 40s are passing around us all the time.
Yes,
And it's a
yes.
very scary thought,
Yeah?
but it's a very real thought.
Yes.
And I know that nobody wants to put their family in a situation or a crisis and they don't know what to do.
Very, very true.
Right. And then also the healthcare proxy. So tell us exactly what that is.
The healthcare proxy that I use has been a document that I drafted myself in the late 70s, and it is a document that states when I can no longer communicate my desires, my intention to my medical professionals that are taking care of me. I then appoint you to be my agent, my healthcare agent. So therefore, that means when the medical and the medical doctors and so forth need an answer, they're going to go to you because I cannot communicate.
Right.
Which really means, if you think about it, you must know what's in my head. You
Mm-hmm.
must know what my desires are. Do I want experimental medication? Do I want to be plugged into a machine?
Right.
Things of that
Life
nature.
support, right.
Right.
Right. So what is your focus for your clients?
My focus for my clients really truly is to preserve your assets so that you can pass them on to your beneficiaries at the lowest expense.
Okay.
When you and I look at the estate tax calculator and you look at your probate expense, I'm going to ask you, are you comfortable with your estate paying that expense? If you say yes, we're good to go.
Okay.
If you say, I don't know, can we do better? We usually can. Then we
Okay.
have to make a value judgment as to whether or not an expenditure to going further than just doing a will is in your best interest.
Okay, wonderful. So let's talk about your services,
Mm-hmm.
additional services. Federal estate.
Right?
So,
Federal estates, as time has passed, has been dwindling with respect to the need for the attorney to complete federal estate taxation documentation because the federal estate exemption number is so high, well over approximately $5.5 million per person before federal estate taxation commences. Therefore, we're less than 0.002% of the population that are impacted by federal estate taxation.
okay.
Most of the estate taxation that we are addressing is New Jersey estate taxation.
Right, okay. And yeah, that's one of the things I was going to talk about also is New Jersey estate services that you offer.
New Jersey estate taxation commences when your assets this year exceed $2 million.
Okay.
The law presently reads that in January of 2018, the New Jersey state taxation will be gone. It will no longer exist. However, what most people don't realize is Trenton has already scheduled a committee meeting after the governor's election to discuss the reinstitution of the New Jersey estate taxation. And all Trenton is doing is mimicking the exact same thing that the federal government did when the federal government taxation became zero.
Okay.
And they reinstated the federal estate taxation thereafter and made it retroactive for 6 or 8 months.
Okay.
So New Jersey will probably, in my opinion, do the exact same thing.
And so then you have federal and New Jersey probate.
Yes.
Yes.
Probate, whether it be federal or New Jersey, will be the same process. It really is the finalization of your estate, meaning all the bills that are incurred in your estate, all the expenses that are incurred, which includes the attorney's fees, the accountant fees, anyone who is involved in the appraisal of any assets, the distribution of your assets. All of those issues are all involved in the probate matter.
Okay.
All right?
All right, very good. So let's talk about your clients.
Right.
What are some important questions that your client should ask?
The client should really ask, how long will this document be valid for? They really should know that when they walk out of here, they have a document and they have a receptacle which would be that trust that we're going to create, or that will be valid for X period of time. And a lot of times that's contingent upon a change in the law that may be coming down the road, or a change in either the law or a change in your intention.
Okay. So what are some common things that you see with your clients? Like maybe something they're misunderstanding, or something between your clients that they have conflict with?
Most of the time, the misunderstanding really represents the lack of a full understanding of the document itself. Too often, I will see a client in my office and I'll say, do you really realize what you've signed? If you bring me a document, and too often that client will say, I don't really know what it is. I went to a practitioner, he told me that I needed A, B, or C, and he prepared A, B, or C. I paid a fee, but I really don't know what it is. The worst scenario that I can imagine, and I've had this happen, is for a client to come into my office, prepare a document, I prepare a document for them, I advise them, and I do this in my consultation and in a letter after my consultation. Don't forget to do A, B, or C. That's called funding or transferring assets into that trust that we just created, for example.
Okay.
And then I see you in 2 years and I say, so what do we put in this trust? And
Right.
you tell me nothing.
Right.
So I look at you and I say, but Marci, what are we accomplishing here? You came to me, you paid me a fee, I created this receptacle, you put nothing into it, so you really have gained nothing.
Right.
You really have to continue with funding or doing things after you finished with the planner's work in his office or her
Right.
office.
Right. So how can you help to make sure that happens?
I follow up with my clients.
Okay.
I will send a letter to a client that I have not spoken to or heard from on the outside every 2 years. I tell each of my clients when they leave my office with executed documents, I want to see you in 6 months.
Okay.
Some of those clients, ironically, and I'm very happy to have this, will turn around and they'll call me a month later or 2 months later, and they'll say, I'd like to come in because either I'm confused about something, or I have a question about how I should turn around, how I should accomplish funding this trust.
Right.
And I say, come on back in, because that's what's the most important thing. With me just creating a document or a vessel for you, and you doing nothing about that vessel,
Right.
that doesn't accomplish anything for you.
Right. So you are available to anyone to explain to them what has really occurred
Yes.
at any
Yeah.
time.
Yes, yes.
Yes, so you make yourself available. That's great.
Yeah.
So one of the things I wanted to ask you, that I'm sure you get this question a lot, is it a flat fee or is this an hourly rate? How does that work?
I'm asked that almost at every consultation.
Uh-huh.
And I've been doing this for, I don't even want to say how long, many decades, and at this point, I usually just smile at that point. I look at a client and shake my head a little bit.
Yeah.
And I always say the same thing. If you want me to do this hourly, I will, but if I do it hourly, I win, you lose. You don't want that.
Right.
I said, you really should have a flat fee, and know exactly where your expense will be.
Right.
And that's the most equitable way for me to justify, to understand my fee, be comfortable with my fee, and for you to know exactly what you're in for, so you will have no surprises. That's the way it should be.
Yeah. So tell us, what's the process? You know, I've decided to come in.
Right?
How does it work?
I like most of my clients, and most of the time I can accomplish this, go to my website, go to the calculator, you do not identify yourself by name, there's no characteristics whatsoever that can identify anything you put on that website calculator with you individually. And when you finish completing 6 or 12 or 13 different opinions, what will be like, for example, the opinion of your value of your house, I need to know the market value of your assets.
Okay.
So once you complete those form, that very brief form, at the very bottom of the page, it will say calculate taxes now. You're going to click on that link, the page will reappear, and it will give you your federal estate tax, if any, your New Jersey estate tax, if any, and it will also give you your probate expense.
Okay.
And by default, my calculator calculates your probate expense at 3%.
Okay.
Statistically, through the United States, probate expense is somewhere between 2% and 12%.
Wow, 2 and 12.
Yes.
Wow. Okay.
And I like to have a 3% calculation, because then I can look at you and say, are you comfortable with a 3% calculation, this number? If
Yeah.
you're comfortable with it, we're fine, we're good to go.
Okay.
If you're not comfortable with it, let's see what we can do.
All right. So now they've done that,
Right.
and they want to move forward. What happens?
If they've done that and they want to move forward, by that, I believe you are saying they don't like that number. They want to become a little bit more aggressive, and they want to eliminate or minimize, you cannot eliminate, but you can dramatically minimize your probate expense.
So let me rephrase this. So if you're happy with the number, then you draw up the papers and move forward. I mean, so there's 2 ways to do it.
Yes.
So you're happy with the number, what do you do?
If you're happy with the number, then the reference that I made earlier to the will that we talked about is fine. That's what you need.
Okay.
Nothing more, nothing less. We should only then be discussing a power of attorney and a healthcare proxy.
Okay.
And then that's your basic package.
Okay.
That's what you need.
Okay. And then you're not happy with the number, then what happens?
Then we talk about your probate expense. We know what that number is from the calculator. And then we look at the probate expense and analyze how much we can reduce that probate expense. I look at that probate expense and say, if I can reduce that probate expense by 50%, I will be aggressive in telling you, I recommend we go down this road of discussing the significance of a revocable living trust. If I can get your probate expense reduced by 75%, I'll be more aggressive.
Okay.
And really encourage you to do it. But it's ultimately your call.
So let's say you've had a living will or a health proxy done, and it's been in existence for a couple of years, 3, 4, 5 years. Would you recommend redoing the will?
I recommend reviewing the document.
Okay.
Probably the body, the corpus of the document will not need to be revised at all. That area of the law that has not changed.
Okay.
What I want to be comfortable with you is the person who you designated 3 years ago, 5 years ago, 7 years ago
Okay.
is still your intended agent to make healthcare decisions for you when you can no longer communicate your intention. Because those are the things, it's life's events that will make you have a change of heart, have a change of opinion, change your mind as to maybe I should not name A any longer as my healthcare agent for a
Right.
multitude of reasons.
Right,
And
yeah.
let's make it B. The document itself will not change.
All right. Well, what are some final thoughts for our viewer?
Definitely address your probate expenses and as well as taxation, of course. All right, be sure that you are comfortable with the practitioner that you're working with. Be sure that he has answered all of your questions. If he has not answered your questions, request to sit down again, have another consultation to review, and most importantly, when you are done and you have executed all the documents, go back and see him down the road a little bit further in the future so you can review with him or her what you've done and what else should be done next. Because there is always a progression in this field. What you've done today may not be adequate 2 years from now.
Well, it's been wonderful having you on. You
Thank
have
Marci.
shared so much valuable information, and I really appreciate it. It's Tarta Law in Midland Park. And Mr. Steve Tarta, thank you so much. We
Thank you,
really
Marci.
appreciate it.
Thank you.
All right, guys, thank you for tuning in, and I'll see you soon.